From supplementary list, item number 1.
My Lord, item number 1, 2, and 3, they are connected matter. And in item number 2, I have filed affidavit as per the order passed by this honorable court on 3rd of July, Your Lordship. Paragraph 2, 3, and 5, it is irrelevant.
Item number 2, papers. You got a copy of it?
Yes, Your Lordship.
No, item number 2, papers. That you keep.
Paragraph 2.
Yes, Mr. Advocate, what do you have to say?
Yes, Your Lordship. If Your Lordship will see the FIR at page 7, which my friend has, page 7 of this. Today morning, second paragraph, Miller. When I was at my house, I received telephone call at so-and-so time from so-and-so mobile number. Caller told that his name is so-and-so. He wanted to meet me personally at the same time. I told that I had appointment doctor, but he said that it is a matter of just 5 minutes and hang up the phone. Then another call arrived and caller again told that he is so-and-so and he wants to meet me. I asked him to come, and when he came, I opened the door for his entry. And the petitioner knows that he is kingpin. And he invites him to his residence. My Lord, both of them are from Belatola. Both of them are called the petitioner.
It is not Belatola, it's Beltola.
Yes, sorry, Beltola, my Lord.
A citizen makes a complaint and you're singing pains for the...
No, my Lord. What I am saying is that we have taken action. We have written to Assam Police. We have written to... this is the complaint.
Where is your writing to Assam Police?
Yes, Your Lordship, I have got it with me. I have in fact named all these things. Confidential letter is there, my Lord. I have got everything, my Lord.
He has a sworn affidavit in which he has indicated who the kingpins are.
Yes, Your Lordship, now...
He has indicated the numbers also.
I deal, Your Lordship, now he is saying that these are the kingpins, my Lord. Now he knows each and every kingpin, my Lord. He knows every kingpin, my Lord. And in my affidavit of DGP, my Lord, I have dealt with this aspect of kingpin, my Lord. Kindly see my affidavit of DGP. In this matter only report.
Page?
Your Lordship will see report in Shalendra Kumar at page, my Lord. 4, my Lord. Page 4.
No.
Of or
Affidavit filed when?
a report has been filed, my Lord.
I've marked it. I've marked it on top.
On 1st July, my lord.
Copy I have. Yes, July.
And in that other matter.
1st July.
Yes, paragraph 5. And the same report is there in the item 1 also, my lord, of DGP only.
1st July in this matter?
Yes.
It's not here.
What date it?
So, Your Lordship, may kindly see the report. Identical report is there of
No,
third.
no, it's not there in this matter.
Third. It was filed on 3rd, my lord. Sorry. 3rd July.
What was
3rd?
3rd July, my lord.
No, 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 no.
Yes, yes.
There's no 3rd July in the file.
In Shalendra Kumar.
In Salendra Kumar, my lord. In item
PIL number? Shailendra Kumar has 2 PILs.
Yes.
One PL.
1 PIL.
A1. 9, my lord.
PIL 9, no, it's not there, part of the records.
So, Lordship, kindly see the same report is there. Same report is there in PIL 2 also, my lord. Identical report is there in PIL 2.
We have filed on that.
Why would they do that?
File in the morning. I've given to the court master.
Yes, there's a report page.
Is 4, paragraph 5. Your Lordship will notice that the registration of FIR is under at the foot of the page of page 4. PS case number 39 within bracket 12 2022 under section 188 34 379. I have requested the police to add 379 theft. Somehow I added, my lord. 120B and then MMDR Act read with section 15 and section 21(3) is also there, my lord.
Paragraph 6, he is in police custody.
His son, my lord. His son, he has been arrested on 15th June. He was having the coke oven plant, my lord. So he was arrested on 15th June. And then, my lord,
Son of the other person.
the person who allegedly threatened the petitioner and he went to his house. And my lord, your lordship will see.
Now,
because,
Mr. Advocate,
yes, your lordship.
in the matter that was before the division bench,
Yes.
I think yesterday.
I saw the video.
Yesterday or day before.
Yes, I saw the video also, my lord. I personally went through the video.
And we have, the order is there also.
Yes, sir.
We've directed the state to show cause.
Yes, sir.
Why we should not. And
Absolutely.
we've prima facie expressed an opinion that it should go to CBI.
Yes, sir.
Because it's beyond the state.
I will try to.
It's beyond the state because it's not being done by people in the state. All these persons, most of these persons are in Assam, and it's an interstate problem. In an interstate problem, your police will not be, even if we had any confidence, which we don't, in either your police or your administration, we would give it to CBI. We'll wait for your reply,
Yes,
and then we'll hand it over to CBI. And thankfully, he has also indicated the names of the kingpins over here.
We have also indicated.
We will wait for. When is the other matter coming, Mr. Khan?
Next week.
Next week. We'll wait for your reply in that.
Yes, sir.
And we'll see if there is any drastic action. Now we are not looking at superficial action. We're looking at some drastic action.
We'll do that.
That is number one. And number two is that these people, we will say that since they are not over here, that all these petitioners, they will be given protection by the Assam police. We'll pass an order to that effect. Is the state of Assam a party over here?
No, my lord.
But in one of the proceedings they are.
Yes, Your Lordship.
In one of the 3 PILs they are parties. So the
Otherwise, 226(3), your lordship. Part of cause of action arose here, your lordship can direct.
that is weak. In any event, there's no problem in that. Pursuant to the leave granted to the petitioner in PIL number 9 of, or in that matter only, to the petitioner, an affidavit has been affirmed by him on
5th July.
July 5, 2023, appending a copy of a complaint lodged with the lodged in the Bushisto police station, Guwahati, on June 30, 2023, to the effect that one Balwant Bhama, an alleged kingpin in the illegal operation of coke plants in Meghalaya, had called the petitioner twice on the morning of June 30, 2023, and thereafter physically called at the petitioner's residence shortly after 10:30 to threaten the petitioner with dire consequences if the petitioner pursued the present PIL, the present petition, full stop. Paragraph. Elsewhere in the affidavit, particularly at paragraph 3 thereof, the petitioner has furnished names and phone numbers of persons who the petitioner describes as kingpins involved in illegal coke plants and illegal coal mining in the state of Meghalaya. Close quote, full stop. Paragraph. Learned Advocate General Learned Advocate General refers to a recent report of July 3, 2023, filed by
DGP.
the Director General of Police in the state. Full stop. Paragraph 6 of such report records as follows, set out paragraph 6 from page 5. Full stop. Paragraph. Learned Advocate General submits that Yudhishthira Bhama, you'd get the spelling from here, is the son of
Balwant Bhama,
against whom the petitioner has lodged the complaint. Full stop. Paragraph. It is, thus, evident that the petitioner has not taken, has not plucked out the name out of thin air, and there may be some basis to the petitioner identifying the kingpins or some of them who are involved in the illegal coal mining and the use of such illegally mined coal in the coke plants in the state. Full stop. This requires to be thoroughly looked into. Full stop. Paragraph. It is unfortunate that the machinery in the state, be it the administration or the police, have been lacking in taking appropriate steps to arrest the illegal mining of coal in the state, despite orders in such regard having been passed by the National Green Tribunal since about 2016 and affirmed by the Supreme Court by 2019. Full stop. Repeated orders have been passed in the present and the connected proceedings, particularly the suo motu proceedings instituted by the court, for the last 15 months, semicolon, but to no effect, full stop. Paragraph. In another matter, the matter before the division bench, PIL number so and so, which focuses on the source of coal used at the illegal coke oven plants in the state, an order was passed on day before yesterday, I think.
Yes. Fourth.
On July 4th, requiring the state to show cause why the court should have any further confidence in its machinery, including the police, and not require the Central Bureau of Investigation to inquire into the illegal mining of coal and the use thereof in coke oven plants and export of the same, particularly since the activities seem to be controlled by persons based in Assam, full stop, paragraph. The relevant PIL number so and so will now appear before this bench so that all matters pertaining to illegal mining of coal, the transportation of such illegally mined coal, the use of such illegally mined coal, the operations at coke oven plants without any permission and license, and the failure on the part of the state to check overloaded vehicles on the state highways and roads can all be dealt with together, full stop, paragraph. In the meantime, in view of the apparent threat received by the petitioner and a similar allegation being made by the petitioner in the transferred matter, PIL number so and so, since the relevant petitioners ordinarily reside in Assam, the Director General of Police, Assam, is requested to take appropriate steps through the officers in charge of the local police stations and the superintendents of police of the relevant districts to ensure the safety and security of the petitioners, their family members, and lawyers representing such petitioners, full stop. The DGP Assam will also look into the complaint filed by the petitioner on June 30, 2023 and ensure that appropriate steps in accordance with law are taken in respect thereof. Full stop. Paragraph. It may be pertinent to record that the Advocate General appearing for the state of Meghalaya submits that confidential communication have been made with the police authorities in Meghalaya to take appropriate steps against persons based in Assam who may be the masterminds behind the illegal operation of coal mining and coke oven plants in the state of Meghalaya. Full stop. It is hoped that adequate attention is given by the appropriate authorities in Assam in such regard. Full stop. Paragraph. A copy of this order will be forthwith transmitted by the Office of Learned Advocate General of the state to Learned Advocate General of the state of Assam for communication to the Director General of Police with appropriate instructions. Full stop. Let this matter appear along with all the connected matters, including the day before yesterday's matter.
Yeah, late.
On
13 July.
On July 13th. 13 July of the week, Mr. It's another Thursday.
Thursday. It is listed on 13 July.
May please, Your Lordship.
Yes.
In item number 3 also, my Lord.
Yes.
There are also continuation of illegal cookment, Your Lordship. And in this also, my Lord, without any valid license, they are running still, and the police has to take any actions against them, my Lord. In the private respondents, I have heard, my Lord. And even they issued a 41 notice to the cookment owner, my Lord, and some appeared, but the cookment are allowed to, my Lord, continue, my Lord, and we collect some documents. We need some. We'll file an affidavit in this regard.
What can we do? What can we do, sir? Yesterday there was a deputy commissioner who came to court and said that the freshly mined coal was coal which has been seized years earlier. If administrative services officials who come through the most rigorous tests anywhere in the world try to submit despite it being apparent that this was glistening coal, that they had been seized several years earlier, what can we say? They are calling day-night.
We have arrested.
And proceeding shamelessly, despite the words that we use in our orders.
We have arrested about 10 persons, 10 co-owners. And
in which 5-star hotels have you lodged them?
Your Lordship, they are in respective police station or police, that I am not aware, but about 10.
Are they there or the drivers there?
No, they are the owners, my Lord. We have given those lists in my affidavit, my Lord.
We have no confidence.
And Your Lordship, we have also, because the problem which we face in the law also, my Lord, that the offence punishable by them under 21C is maximum 5 years. So under 41A first we have to give them notice. Those who have not cooperated, we have arrested them, including 10 of them. And
that is one thing.
Yes.
The other is that is going against them. But no law prevents you from dismantling
Yes, Lordship.
whatever is illegal.
Your Lordship, in fact, Justice Kataki has...
That is where it will hurt most.
Yes,
because that is which costs money.
Yes, Lordship.
Over here you keep them 10 days in jail, they're fine.
They will go. Well, what we have done also, besides this also, Justice Kataki has also visited. In fact, all those coke oven plants have been sealed and some of them have been dismantled. A demand of 2 crore rupees was made for dismantling. Now we are going to use the limited blast to dismantle the chimneys so that they can't operate clandestinely. So that exercise will also be done, Milord.
Convince us that you are taking drastic steps.
We
now
will do
we
that.
won't, these superficial things we will not. That's why we requested Mr. Khan.
And third thing, Milord, regarding Deputy Commissioner, I had detailed interaction with him. What has happened in that particular issue, Milord, that coal was seized because in Gaswapara they are dumping the coals next to the highway. So those coals were seized and recently, not those the inventorized coal or coal which were part of the coal dumps, Milord. They have been recently seized and FIR have been registered against them.
Have you seen the video?
I have seen the video.
Registration numbers are also evident.
Yes, Your Lordship. There are one more aspect which I wish to place before Your Lordship. One is, Milord, that now coal auctions are taking place. Once since coal, and for example in Chalendar Kumar or in Monu, in Champion, there is a challan which was placed in the PIL, Milord. That challan was issued pursuant to the auction which has taken place under coal.
You are picking out one.
No, but there are problems which I do not deny, Milord. There are issues, Milord. That's why we have repeatedly asked the central government to give us the extra manpower so that we have, so that we can have.
Where have you asked?
We have, since 2016, we have been asking a lot. Even NGT has recorded in 2016 order also. NGT has recorded. NGT has asked us to go to the home commissioner. And there's, I can place those letters with my affidavit, my lord.
Why have you not installed additional way bridges?
We have, my lord, 2 more have been installed, and there we are lacking there. We are lacking there, my lord.
Way pads do not cost any money.
Yes, Lord.
That they cost a few lakhs of rupees.
Yes, Lord. There are issues that I bow down. I can't go beyond what I see on the ground. That is there.
And those, who is stamping on behalf of the DMR that this is coal of external origin? On what basis is the stamp purchased?
So what has happened there also, my lord?
On what basis is that stamp
Yes,
issued?
I'll just explain what the Justice Kataki was. So he has laid down the parameters. So anybody who wish to export coal from outside Meghalaya to Bangladesh, first he has to approach DMR with DMR here in. Then he has to give at least 10 or 12 documents checklist. Those checklists are to be verified, and then the challans are issued here, and then he will have to first entry gate, their CCTV, and then exit gate. That's the mechanism, but there are loopholes which we have noticed also, that they are trying to browbeat that system. They are trying to do that also, and in 1 or 2 cases, especially in Champion, we have noticed that also. So that is because earlier there was rules have been framed, and under those rules, under MMDR, now they are being permitted, because from Nagaland, from Bhutan, from other, or even Jharkhand also, in one of the cases, it is from Jharkhand also. We will place, my lord, whatever we could try to satisfy your lordship.
Very well.
I have a copy of the affidavit filed by learned DGP.
The report.
This one.
Oh, 2 other things. The 15th interim report has been filed by Justice Katake on June 30, 2023. It will be open to the state to deal with the contents of such. You got a copy?
No, we have.
Deal with the contents of such report after obtaining a copy thereof from the officer attached to this court. Full stop. Paragraph. Let a further ad hoc remuneration of rupees 4 lakh be released to Justice Katake in addition to the other expenses for which provision has been made in previous orders.
That report may kindly be furnished to us also.
Yes.
Justice Katake report.
Obtain a copy. Paragraph. It will be open to all the parties in the connected proceedings pending before the full bench or transferred by this order to the full bench to obtain copies of the latest report filed by Justice Katake.
Deep.
From the main list, item number 1.
Lordship, we have disposed of the matter before the executive committee, and we have served a copy of the order on all parties, including the writ petitioner. And I'll just put a word to the writ petitioner, if he can bring it by way of an affidavit in case he wanted to say anything.
It is submitted on behalf of the District Council that the decision has been taken and duly communicated to the writ petitioner. Paragraph. Let the matter appear 3 weeks since. You're not saying anything. You want to challenge, you don't want to challenge.
Yes.
Tell us next time and then we dispose of the matter.
Yes, well,
Much obliged.
much.
Just the one matter?
1 and 2.
One matter before this bench?
Yes, sir.
2 matters, but same issue.
Any mention for unlisted matter? Any mention for unlisted matter? Supplementary cost list, item number 1.
Yes.
Absolutely, Lordship. Lordship, read appeal against the order dated 28/6/2023, passed in MC case number 90 of 2023,
Yes.
arising out of writ petition 104 of 2023.
Yes.
Lordship, here the writ appellant is a contractor and he has participated in a tender, which tendered and...
The writ petition has been disposed of?
Yes, Lordship. The writ petition is disposed on the basis of the miss case.
That's all right.
Then, Lordship, because of which I filed this writ appeal. In the tender was regarding ration supply to the Assam Rifles, Lordship.
Ration supply to Assam Rifles?
Yes, Lordship. Lordship, I can kindly post page number 14.
Come to page, let us, what is the order?
Lordship. 294, Lordship.
What was the order passed on 12/5/23?
Lordship,
The status quo was possible, not to proceed with the opening of the financial bid, my lord.
Very good. And miscellaneous application was filed by Assam Rifles?
By the private respondent, my lord.
by private.
As a private respondent, the contractor who had been awarded.
No, Lordship.
He was not
against-
awarded, my lord.
But who was a successful bidder?
No, Lordship.
Technically, my lord.
Technically.
Lordship, there was one clause, 6E, which state that he have to give.
Yes, yes, we're reading the order. What are sole issues? Yes.
Lordship, okay. Then my case is basically on 6E, Lordship. It says the bidder will submit details of the existing contract.
Nothing.
Lordship, when
View
there's
has been taken. They have also addressed it.
But Lordship, in the order, para 10, Lordship, this court has examined the clause in question, and though it is not very clear as to what would constitute an existing contractor and whether it would be mandatory for a contractor to submit details of contract with other entities, in the view of the pointed submission that the technical rules have since been opened, this court will not venture in the same in the incident proceeding. But Lordship, it is clearly given
That's
that
all right.
That's
all right. That's the view which has been taken. We don't interfere with the view. You had also complained to the grievance cell. The grievance cell dealt with your complaint and said that there was no material impact on the contract. In matters of contract, the employer has to be given sufficient elbow room. Unless it's something which is very drastic, we will not interfere.
Lordship, I have no case then.
Thank you. No. The appeal arises out of an order dated June 28, 2023, by which the appellant's writ petition, WPC number 104 of 2023, was disposed of in view of an order passed on an application by the third respondent to the writ proceedings seeking a vacation or modification of the initial interim order passed on May 12, 2023 in the said proceedings. Paragraph. The order dated June 28, 2023 passed on the relevant miscellaneous application, recorded that the sole issue that was asserted by the petitioner pertained to the acceptance of tender documents from the third respondent to the petition, full stop, the writ petitioner complained that the third respondent to the petition did not fulfill the technical bid requirements in terms of clause 6 bracket small e of the tender documents. Full stop. Upon noticing the entirety of clause 6e, the court was of the opinion, the writ court was of the opinion, on May 12, 2023, that an arguable case had been made out and, as such, required the respondent numbers 1 and 2 not to give effect to the acceptance of the bid by the third respondent to the writ petition. Full stop. Paragraph. Though such interim order was of limited shelf life, an application was filed by the third respondent to the writ petition for vacating the order, full stop. By the time such application came to be taken up by the writ court, the interim order had already expired, and the initial prayer of the third respondent to the writ petition was that upon the interim order having expired, the first and second respondents to the writ petition were free to take appropriate steps in accordance with law, full stop. However, the court addressed the substance of the writ petitioner's grievance instead of allowing the matter to go by default upon the interim order not being extended, full stop. The court noticed that clause 6e of the tender documents had to be read in conjunction with clause 6, and an interpretation was sought to be given both by the third respondent to the writ petition and by employer Assam Rifles that existing contracts with the Assam Rifles had to be disclosed and not existing contracts with other employers, full stop. Though the issue was contested on behalf of the writ petitioner, the writ court was of the opinion that no final view ought to be expressed on such issue, particularly since the tender documents provided for a grievance redressal forum for any bidder to carry a complaint to such body, full stop. The writ petitioner had carried a grievance which the relevant body disposed of by observing that the failure, if any, on the part of the third respondent to the writ petition to disclose other contracts did not have any material bearing on the matter, full stop. Indeed, it was the submission on behalf of the employer that the employer was satisfied with the financial capability of the third respondent to undertake the supply of food to Assam Rifles, full stop. Once so much is evident, the writ court would scarcely interfere in a matter pertaining to the award of contract, full stop. High authorities instruct that even a government or other authority answering to that description in Article 12 of the Constitution has to be allowed sufficient elbow room and latitude to award contracts, and unless there is grave prejudice or malice demonstrated, the court would not interfere in such matters. paragraph, since the process of identifying the process of identifying the would-be contractor had already been completed, and the issue that was raised by the writ petitioner was found to be devoid of substance, the order impugned dated June 28, 2023 does not warrant any interference, full stop, paragraph, accordingly, WA number so and so is dismissed. There will, however, be no orders to cause. Thank you.
From the main list, item number 1.
This is the matter which was remanded back from the Honorable Supreme Court regarding the Provident Fund scheme for the college teachers of Meghalaya, Malaysia. Considerable progress has already taken place. They have constituted a board of trustees to look into the maintenance of the fund.
Petitioner submits.
And my lord, there are two aspects which now remain, perhaps.
If you want to do the matter, do the matter.
My lord.
But if you are waiting for some other negotiations or some other progress,
that is what I was proposing.
That's will adjourn the matter. There is no point. The petitioner submits that upon the remand of the matter by the Supreme Court, steps have been taken by the state government to redress the petitioner's grievances. Paragraph, it is also the common submission of the parties that an expert committee has been set up.
Board of trustees.
That a board of trustees has been set up to look into the various aspects and make recommendations as to the extent of
The Board of Trustees have been set up under the Act to implement 1969.
Board of Trustees has been set up under the what Act?
This Meghalaya, this is, Your Lordship, the name of the Act is?
Meghalaya College Teachers. Meghalaya Non-Government School and College Employees Centralized Provident Fund Scheme Act 1969.
1969 to implement the provisions of such Act, full stop, paragraph, accordingly, at the request of the parties, the matter is adjourned for 2 months, full stop. It is hoped that the disputes would be resolved within such time, full stop, then give it a date.
Dispute has been resolved, only scheme is and bank account is.
And the bank agreements have to come up.
That's only.
I'm obliged.
Thank you.
Item number 2.
In this matter,
Yes.
I appear for response number 5, the contractor.
Lordship, as per the order of 28/6/2023, there was a direction was given to the state to at least clear the debris from the roadside along the PS stadium. Lordship, we received instruction that the same has been done.
I'm sorry to say, my lord,
Has been removed.
no, my lord.
And the road is now navigable.
So far, the debris, Lordship, if I just explain, because the wall collapsed, there was a mud. So there are two aspects to it, Lordship. One is to clear the debris. Second is to make the road motorable. But motorable would be slightly an issue because of the collapse, and there could be further danger in case things doesn't happen and we having monsoon season. So the debris part, Lordship, the instruction that we received, the contractor responded on 5, they have cleared it. And the road part will be, as soon as we get clearance that it can be used, then that will be all.
That is not correct, my lord. This is the photograph of yesterday, my lord. My client has communicated to me. The photographs is very clear.
Show it to him first.
Well, all muds, my lord. If it rain a bit, my lord, people cannot walk over the road.
Yes, but then before the repair is done,
No, only the mud. If the mud is removed, my lord, there is a road, cemented road. If the mud is removed, my lord, they can walk or they can use the small two-wheeler vehicles and all.
do that.
Lordship, as I submitted, because there was a mud slush. And
You have to do that.
Lordship, we have to do it.
You can't.
No, we are not
say
giving
that
it.
till September. That let
No,
the
no,
repair go.
absolutely not, Lordship. No.
And what about the warranty? What steps have been taken?
No, so as far as the warranty is concerned, my lord, the respondent number 5 is liable for maintenance of the entire stadium for 1 year, my lord.
You are the respondent number 5. So then you have to reconstruct it.
My lord, we are reconstructing, my lord.
At your own cost.
At our own cost, my lord, and within 2 months we'll reconstruct the entire wall, my lord.
Very good. We'll record that, and we'll keep the matter after 2 weeks for the debris part of it to be absolutely done.
Absolutely.
So that it becomes motorable.
Motorable also.
And thereafter, we will keep it 2 months later to ensure that the reconstruction is complete.
My lord.
The matter pertains to the collapse of the PS Angma Stadium in Tura, full stop, paragraph. When this petition, filed in public interest, was received on June 28, 2023, the fourth respondent is the contractor.
Fifth respondent.
Fifth respondent.
Very good.
Fourth respondent is the EPC consultant, my lord, Hindustan Steel Works.
Very good. The fourth respondent, which was the consultant to the construction project, was required to indicate the contractual specifications that may have been breached and the period of warranty within which, during which the contractor was required to set right anything found remiss. Full stop. Paragraph. The fifth respondent contractor is represented and submits that the warranty was for a period of 1 year to maintain and the stadium in good repair. Full stop. Accordingly, the contractor is now engaged in reconstructing the collapsed portion. Full stop. According to the contractor, such reconstruction work in proper order would be completed within 2 months. Full stop. Paragraph. As far as the debris that blocked a side road is concerned, the petitioner complains that despite the previous order requiring the road to be made motorable, no steps have been taken on behalf of the local administration in Tura. Full stop. However, learned additional Advocate General appearing for the state submits that the debris that was piled up as a result of the collapse of a part of the concrete structure has been cleared, but the collapse also resulted in mudslides. Full stop. The state says that it will take some time for some kind of temporary protection to be put up so that the road is motorable. Full stop. Paragraph. Appropriate steps in such regard should be taken before the matter appears next, a fortnight hence, so that local residents using the road have access through such road without any further impediment. Full stop. Let the matter appear 3 weeks hence.
We'll do it our own cost, my lord.
The contractor has also volunteered that the entire repair work will be done at its own cost. Full stop. There is no doubt that the fourth respondent or the state will ascertain the structural integrity of the renovated portion and indeed the entirety of the balance construction once such renovation is completed.
In fact, my lord, what has happened, this is of course highlighted in the BTA, is a very small wall, my lord, that has collapsed. But it is highlighted as if the entire stadium is collapsed, my lord.
No.
Very small details.
We have the video.
Very well. I build a house, one room collapses. The entire house has not collapsed. Is that something?
It is something like a bathroom collapse, my lord, outside, my lord.
We have the videos. If we play the videos, my lord, it will be more clear.
We will take all steps, my lord.
Why? You had used mud instead of cement?
But that was the feeling, my lord.
Okay. Yes.
Item number 3.
May it please your lordships. But these are the 4 connected income tax appeals, your lordships.
We remember.
My lord, on the last occasion, lordship tentative view that first option, my lord will decide. Second option, my lord, lordship might remand it back to the tribunal. And lordship asked us to find out, my lord, whether the president of the tribunal has the power, my lord, to constitute a larger bench. My lord, I have come across, my lord, this has been clarified by a judgment. He can.
He can.
He can.
Very well. Let us hear them. For due, let us hear them.
May I please, Lordship. Lordship, here the question is very frank, whether Mahari judgment is applicable here or not. Lordship, my false submission, in Mahari's case, Lordship, the issue was whether a group of person or group of family will be entitled to benefit on exemption under section 1026. Lordship, in my humble submission, that judgment is not applicable here because we can distinguish the facts of that case and this case. Here, Lordship, the petitioner, appellant is a partnership firm, Lordship. And under section 231, Lordship, it is defined. Lordship, may take up section 231, Lordship.
Yes.
Here the person includes an individual, 2 a Hindu undivided family, 3 a company, 4 a firm. So the partnership firm is a legal entity under the Partnership Act, Lordship, Income Tax Act, Lordship, and they have to assist separately, Lordship. Under section 184, Lordship.
184 says.
184.
184 says that you have to give the documents when you need exemption.
Yes.
And in future, you have to also indicate every year that exemption continues.
No, Lordship, may I read, Lordship, yes. 184. A firm shall be assessed as a firm for the purpose of this act if 1. The partnership evidenced by an instrument. 2. The individual shares of the partners are specified in that instrument. That is available. The partnership firm is a registered firm and their share has been...
Read subsections 4 and 5.
Not. 4. Where any such change has taken place in the previous year.
No, then 3.
Then when a firm is assessed as such for an assessment, any assessment year, it shall be assessed in the same capacity for every subsequent years if there is no change in the constitution of the firm.
So therefore, if a firm, let us say, is entitled to, let us say, some exemption benefit,
yes, Lord.
Then as long as the constitution of the firm does not change, it will carry on.
Not so.
But if the constitution changes, it will inform the department the constitution has changed.
Yes, Lord.
For the department to apply its mind,
yes,
whether or not it will be entitled to the same exemption.
Not so.
Now, therefore, in a situation like this, where an association of persons, family is also an association of persons.
Not so.
Partnership firm is also compendious.
Yes.
That's the classical definition of partnership firm. So all entities over here are tribals.
Correct.
If A had done the business, if one of the partners had done the business in his own name, it would have been entitled to the benefit.
Yes, Lord.
2 persons pool their resources to do it when both persons individually would have been entitled to the benefit. Then there would be a case for an exemption which is made out in line with the Mahari decision.
Lordship, in Mahari's paragraph 5.
Yes.
Lordship,
yes.
we have carefully applied our mind to the controversy. The word family is a popular expression. It should be given a normal meaning and should not be construed technically unless it is so intended by the statute. Most common of the word family refers to a group of persons consisting of parents and children, father, mother and their children, immediately kindred. It is also mean of collective body of persons who live in one house and under one head or management, a group of blood relatives, all the relations who descend from a common ancestor or who spring from a common root, a group of kindred persons, husband and wife and their children. So
now, imagine in this case, a partnership with firm is formed by husband and wife. The Mahari dictum will apply to it?
Lordship, in my humble submission, in view of the specific provision in income tax, Lordship, probably that will not be applicable here, Lordship. This is my humble submission. Because under section 184, Lordship, and in 231, individual has been defined, Lordship. Found partnership of individuals, Hindu and divided family and firm. And 184 says that a partnership firm is to be assessed separately, Lordship. And since it is a separate legal entity, so in my humble submission, that judgment will be, the proposition held by the, in Mahari's case, not be applicable here, Lordship. This is my humble submission. And it is a registered partnership firm, Lordship. Their share has been defined in that instrument also, Lordship.
Registered or unregistered hardly makes a difference.
No, even, Lordship, and their PAN card also reflects that they are registered as on the basis of a partnership instrument, Lordship. So this is my humble submission,
Lordship. That's a limited case.
Yes. And with regard to, Lordship, remand of the case, Lordship, probably Lordship has power to remand the matter if Lordship thinks so. This is my humble submission.
Tell us.
Yes,
because
so far, my Lord.
Definition.
Yes, exactly. What my learned friend is.
1026 refers to individual.
Lordship.
231
Madam.
defines person.
Yes.
And person is distinct from an individual.
My Lord, just 231, my Lord, if I can just read out once again. Person includes an individual, number one. Number two, a Hindu undivided family. Number three, even a company. 4, farm. Then 5, your Lordship, an association of persons or a body of individuals, whether incorporated or not. Then my Lord, local authority, etc., etc. So my humble submission, my Lord, even within the definition of person, my Lord, an association of person, a group of person, for example, in the instant case, husband and wife, your Lordships, my Lord, they also will be covered by the definition of person, your Lordships. And Lordship, if you look into the opening paragraph of 1026, it says the income of the following persons. And as I have pointed out, your Lordship, wherever the intention of the legislature was to exempt the individual income, for instance, your Lordship, resident of state of Sikkim, they said individual income of the state of resident of Sikkim. But this is not so, my Lord, in 1026. It's a income of a tribal. And as I said, my Lord, tribal, my Lord, has been extended to a class, your Lordships, and Mahari and Sons, my Lord, has also looked into it. This is a law laid down, my Lord, way back in 91. And my Lord, it has been holding the field for last 31 years, your Lordships. And now what happened, my Lord, most of the tribals, people residing in the tribal area, most of them, they have adjusted their business, my Lord, following this law laid down by the court. And my Lord, one more thing, your Lordships, I don't know, my Lord, even, my Lord, there was a decision on the same issue. And there was a reference made before this Honorable Court, earlier to Mahari and Sons, between the same party. That was also a case of Mahari. There also the Honorable Court has held, my Lord, they are entitled for exemption, even if in group they are doing the business. And SLP was preferred. Even that SLP
That's neither here nor there.
is not entertained, my Lord.
Neither here nor there.
So, my Lord, coming back to the farm, what my learned friend is saying, legal entity. Now, these has been, my Lord, from P. Chidambaram to other cases, series of this, they say very limited purpose. So my humble submission, my Lord, in that...
what is the provision for a larger bench?
My Lord, I'm coming.
There's a
255.
There's a precedent of the What for?
President.
Income tax tribunal.
Yes.
There's a precedent.
President. 255, Your Lordship.
Subsection 3.
255, subsection 1 and 3. Judgment in my book, Supreme Court. Citation.
Two 255 4.
255 1 and 3, my lord. 1 and 3.
3.
Lordship.
President sitting singly.
President or any other member of the appellate tribunal authorized in this behalf by the central government may, sitting singly, dispose of any case which has been allotted to the bench of which he is a member and which pertains to an assessee whose total income as computed by the assessing officer in the case such and such, and the president may, for the disposal of any particular, constitute a special bench consisting of 3 or more members, one of whom shall necessarily be a judicial member and one accountant member.
Special bench, president of the tribunal and the board to constitute a special bench of 3 members.
No,
my lord, these
issue,
my lord, on the request of the member of the Tax Bar Association, Andhra Pradesh, made to the president, a full bench was constituted. The reason cited therein, my lord, with regard to the interpretation of 111 J, my lord, that is pertaining to some special privileges to the companies, there were conflicting decisions. So a request was made to the president. Now the president constituted a larger bench and the matter was referred. Now these were challenged before the High Court, saying that he did not have the authority to constitute. He could constitute only when there is a dissent and by a judicial order a reference has been made. Now matter ultimately reached Supreme Court. Supreme Court examined the scheme of this provision. They said no. As per 1 and 3, my lord, he has the power. Even Suomoto, if he notices there are some kind of conflicting decision, even Suomoto he can constitute a larger bench. Well, if I can hand over this judgment.
Yes.
The relevant paragraph is paragraph 14 and 17. What is it?
Madras High Court.
Paragraphs?
Relevant paragraphs 14 and 17, madam.
This is in our favor. Yeah. The High Court has not formed the full bench. They have decided earlier to follow the earlier decision of the tribunal.
Substitute 1983.
How many matters are there?
3, my lord. These are from arising out of a common judgment.
Common judgment.
Common judgment. Only difference, my lord, in other cases, the constitution of partnership is between the brothers, amongst the brothers. First one, the lordship is
Wife,
husband,
second, brothers.
and the next 3 are from between brothers.
Very well.
Lordship, the rule was amended in 1983.
Yes.
And the subclause 3 was inserted. Lordship, please.
What does it provide?
It says that the bench means bench of tribunal constituted under subsection 1 of section 255 read with subsection 2 thereof and includes the president, senior vice president or any other member sitting singly under the provisions of the subsection 3 of the said section and a special bench constituted under the same provisions.
These 4 appeals these 4 appeals involve a common question of law. Full stop. In short, the issue is whether the ratio decidendi in the judgment reported at, give us the Maori report reference.
Maori report.
(1992) 195 ITR page 630. What?
Bracket Maori. What is the name of the case?
Name of the case is Lordship.
Commissioner of
Income Tax versus Mahari and Sons.
Commissioner of Income Tax versus Mahari and Sons. Bracket close. Would be applicable in these matters. Full stop. The ancillary issue is whether the dictum in Mahari and Sons still holds good despite apparently contrary judgments of the Supreme Court pronounced in matters pertaining to the interpretation of a taxing statute and when the benefit and whether the strict interpretation of an exemption clause in a taxing statute. Full stop. In Mahari and Sons, members of a family, all of them tribals and entitled to the benefit under section 1026 of the Income Tax Act 1961 were engaged in a business, and the question that arose was whether the exemption granted under Section 1026 of the Act was restricted to an individual or whether the same could be extended to a group of individuals, particularly if they were family members. The Guwahati High Court ruled in Mari and Sons that when certain individuals who belong to the same family had set up the business jointly, they would be entitled to the benefit of the exemption under Section 1021 of the Act. 1026 of the Act, paragraph. In the common judgment and order of the Income Tax Appellate Tribunal impugned herein, the tribunal found that the law laid down in Mari and Sons no longer held good. The basis for such view was that subsequent judgments of the Supreme Court questioned the previous principle that a taxing statute had to be interpreted strictly and the benefit of the doubt had to be given to the SSE. Full stop. The tribunal was of the opinion that even though a taxing statute, the law as it now stands is that the taxing statute has to be interpreted strictly, but it no longer holds good that the benefit of doubt must go to the SSE. Several Supreme Court judgments have been read by the tribunal in the impugned order to lay down the law in such regard. Paragraph. The further ground indicated in the impugned order is that at any rate, it is axiomatic that when an entity or any person, when a juristic entity seeks to claim the benefit of an exemption, it must fall within the classes of persons to whom the exemption has been indicated, and an exemption clause cannot be charitably interpreted to enlarge the scope thereof and confer benefits on others not specifically intended to be granted the same. Full stop. In such regard, the tribunal has held in the order impugned that when Section 1026 referred to an individual being a member of a relevant scheduled tribe, and the income of such person accruing in one of the notified areas, comma, the benefit under such exemption could not be extended to persons who are defined in the statute as such. Other persons cannot be regarded as individuals within the restricted meaning of that word in section 1026 of the Act. Paragraph. In such context, comma, both the tribunal in the order impugned and the department in course of the present appeal have referred to section 2(21) 2(31) of the Act and section 184 thereof. Full stop. Both the order impugned also reasons that since an individual has to be seen distinct from a partnership firm, in view of section 1031 of the Act, 231 of the Act, 2(31) of the Act, comma, an association of persons belonging to the same scheduled tribe where their incomes accrue within a notified area will not be entitled to the benefit under section 1026 of the Act. Full stop. Paragraph. In the present case, comma, in the present appeals, comma, in one of the matters, the registered partnership firm has a husband and wife partner, has husband and wife as partners. Full stop. In the other matters, comma, uterine brothers constitute the partnership firm in each case. Full stop. Going by the dictum in Mahari and Sons and comma, particularly comma, the interpretation of the word family made therein, comma, it would appear that an association, comma, even if it be a partnership firm, comma, between a husband and wife or between a brother and another would be entitled to the same exemption as any of the individuals would, as any of the partners would in their individual capacity. Full stop. Paragraph. It cannot also be missed that the rule which has been enunciated in Mahari has held the field for more than 3 decades, and persons may have organized their businesses in accordance therewith. Full stop. Paragraph. There is no doubt that the appellate tribunal noticed the dictum in Mari in the common order impugned and, in effect held that such rule was per incuriam or, at any rate, no longer good law in view of subsequent Supreme Court pronouncements, the exercise appears to have been done in a rather cavalier manner without covering the entire gamut of the discussion possible on the issue. Full stop. For instance, the tribunal makes no distinction in the order impugned between a partnership firm with close relatives as partners and any other partnership firm where the partners are unrelated. Full stop. Despite the recognition of the wide ambit of what can be called family business in Mari, the order impugned places reliance only on the fact that close relatives had formed a partnership firm, while missing out the applicability of the dictum in Mari by virtue of the partners being close relatives. Full stop. Paragraph. At any rate, none of the Supreme Court judgments referred to in the order impugned by the tribunal expressly deals with the situation covered by Mari and Sons. Full stop. General dicta pertaining to interpretation of a taxing statute and the exemption clause contained in a taxing statute have been relied upon by the tribunal in the order impugned dated
13/9/2019.
to
13/9/2019.
13/9/2018.
September 13, 2018, to come to a conclusion that Mari and Sons, that the principle decided in Mari and Sons no longer holds the field. Full stop. Paragraph. At the same time, when courts take up challenges, when constitutional courts take up challenges to orders passed by specialized tribunals, such courts have to tread with extreme care and caution Full stop. A body that deals with a particular type of matters on an everyday basis would be expected to have greater command over the law applicable in the field, and a constitutional court would not interfere with a view expressed on interpretation unless it appears to be grossly inappropriate and almost outlandish. Full stop. Paragraph. Balancing both sides dash the fact that the dictum in Mahari and Sons, everywhere it will be Mahari and Sons, a dictum in Mahari and Sons has held the field for 3 decades, and the recognition that the order impugned has been rendered by a specialized tribunal, comma, it is deemed fit and proper to remand the matter before the appellate tribunal with a request to the president of the tribunal to constitute a larger bench without including either member who was a party to the order impugned, comma, for the consideration of the entire gamut of the matter. Full stop. The President is requested to ensure that a larger bench of at least 3 members is constituted within a month of the receipt of an authenticated copy of this order, with a request to the relevant bench to dispose of the legal issue which has arisen as expeditiously as possible and, comma, preferably, comma, within 3 months of the first sitting of such bench. Paragraph. ITA so-and-so, 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 and so-and-so are disposed of without expressing any final opinion on the legal issues, on the primary legal issue which has been raised. Full stop. None of the observations herein would stand in the way of the special bench of the appellate tribunal deciding the primary legal issue in accordance with law. Paragraph. There will be no orders to cause.
Much okay.
Obligement.
Item number 7.
One more. It goes without saying that no coercive measures will be taken by the department in terms of the order impugned till such time that a final view on the legal issue is expressed by the special bench.
Item number 7.